The ruling contains an extract from a letter sent to this official by his superiors, saying that as the detainees in question were not within our custody or control, the law does not require you to intervene to prevent this. While this may be the case in legal terms, in moral terms, surely the government was obliged to make the strongest representations to the United States government against this form of treatment. May I ask whether such representations were made? My remaining questions concern the immensely important issue of intelligence cooperation between the US and UK that the Foreign Secretary has described. Will he confirm, I think in a way he has confirmed in his statement, that this relationship is unique in the world and is of immense value not only to the UK but also to the United States, and that the disruption of that relationship would have serious consequences for the US as well as for this country? Lord Justice Thomas expressed dismay at the threat of the gravity of the kind made by the United States government that it would reconsider its intelligence sharing relationship with the UK. The Foreign Secretary has reiterated that no threat of that kind was made. Is he suggesting that the Court of Appeal has misrepresented the United States position? And most importantly of all, in my view, the Prime Minister's spokesman said yesterday, "We have not engaged with the new administration on the detail of this case." Is it correct that the government have had no discussions with the Obama administration on this issue? And looking at how matters should now proceed, consistent with the strong and welcome stance of the new US administration on torture, and with our own views in this House, may I finish by pressing the Foreign Secretary on this point? Should not the view of the Court that, as they put it, the requirements of open justice, the rule of law and democratic accountability demonstrate the very considerable public interest in making the redacted paragraphs public, weigh heavily with all of us and indeed with our American allies, particularly given the view of the Court, if this is correct, that nothing in the redacted paragraphs could possibly be described as highly sensitive classified United States intelligence, if that view is correct? And given the change of administration in the US 2 weeks ago, the changes in policy that have resulted, and the changes of personnel in the CIA in the last fortnight, would it not be right to put it to the US administration that it could change its approach to this case without fundamentally breaching the principle of which the Foreign Secretary has rightly spoken? And would it not be a way forward that we could all support in this House to ask them even now to change their position?
Madam Deputy Speaker, the right honourable gentleman is of course right that in respect of the closure of Guantanamo, in respect of action against torture, in respect of the rejection of extraordinary rendition, as it's sometimes called, the House is united and the government has taken practical steps to put that into practice. Mr. Speaker, his first and seventh questions related to our engagement with the US administration about what he called this case. And I want to be absolutely clear about this. I did indeed raise the case of the remaining Guantanamo detainees of British residency status when I met Secretary Clinton on Tuesday, and I confirmed and reiterated to her that we remain determined to secure their release and return. As I think he may have slightly misspoken, that the previous administration had acceded to this request, and the current administration are continuing to commit themselves to the request for release and return. And so Mr. Mohamed will indeed be coming back to the United Kingdom, and that raises precisely the questions of security and the arrangements for that he led into. And I can assure him that we are going to make sure that the return of Mr. Mohamed, after indeed 8 years, as he says, is done in full accordance not just with his rights but with British security considerations. In respect of the arguable case that he quoted, the investigations of the US system are continuing. And of course it is a very complicated system because first of all there are the military commissions, then there are the federal courts, and then there is the decision of the Obama administration to wind up Guantanamo and wind up the system of military commissions. And so I think that the right thing to say is that those investigations remain at the heart of cases in the US system and of cases that are being brought in our system. And so those investigations continue. In respect of the allegations of British complicity, as my right honourable friend, the Home Secretary, made clear on the 23rd of October, those matters are now with the Attorney General consulting the Director of Public Prosecutions. In respect of the representations, his fourth question was about the representations that we have made in respect of allegations of torture. What I would say, I think he quoted one particular case from 2002, and I want to go back before I answer specifically on that case to make sure that we give him exactly the right answer. What I would say to him is that our representations in respect of torture have always been clear in public and in private, and one example I would give him is the debate last year about the question of whether or not waterboarding constituted torture. We were absolutely clear in public and in private that in our view it did constitute torture and that it was reprehensible on that basis. So I can assure him that the British government has remained fully engaged on that issue. In respect of the unique intelligence sharing relationship, that is indeed very, very important, and the ISC has commented on the value of that relationship at various points. I think that the word threat was the word used by the Court of Appeal. The fact that I described, that the intelligence sharing relationship is based on confidentiality, and that if another country gave away our secrets, it could not but have an implication for the way in which we judged the amount of material to share with them, and that the Americans have made clear in public documents that they would see serious and lasting harm from the disclosure in our courts of their information, it's clear that the relationship would be affected, but it's the word of the court who used the word threat. Finally, Mr. Speaker, there is the question of an American decision about what to disclose in public, and I would emphasize that it must be an American decision. Only they can make a decision about whether sources, their own or others, are compromised by the disclosure, in the same way that only we can make decisions about whether our information disclosed to the public would involve the compromise of sources. And so to that extent, I am not going to join a lobbying campaign against the American government for this decision. It's a decision that they have to make, given their knowledge of the full facts in respect of the sources that they depend on and the sources that they do not want to compromise. What I am clear about is that our decisions are for us and their decisions are for them, and to that extent, this case hinges not on the content of the redacted paragraphs, but on the nature of the redacted paragraphs, which is that they are American paragraphs, they're American evidence, in the same way that our intelligence sources are our property. And it's on that basis that we have approached this issue, which I think is the only basis on which to preserve the sort of confidentiality and trust on which this sort of relationship depends.
Ed Davey.
Can I thank the Foreign Secretary for his statement and for the support he and his department have given to Binyam Mohamed. But the Foreign Secretary rightly says that his judgment is on the line whether to take a threat, and it was a threat, of non-cooperation on future intelligence sharing from our closest ally seriously, or whether to allow information on criminal acts of torture to be published. So will the Foreign Secretary confirm that the Court makes it clear that the publication of the summary of intelligence reports under question would not have created a security risk to the United States, that it would not have revealed the name of any agent, the location of any secret establishment, or the methods of any intelligence gathering? The truth is that the question of the publication of this summary was not about security and intelligence, it was about whether or not to cover up torture, and the United States' interest in avoiding political embarrassment and potential criminal investigations against their security services. So we have a bizarre situation. But this is not a threat to our security coming from terrorists, but a threat to our security posed by our closest ally over an issue relating to democratic accountability and the rule of law. So isn't it the case that the British government has just rolled over in the face of a scarcely credible threat from a friend? Isn't it the case, Madam Deputy Speaker, that both this government and President Bush's administration have confused intelligence with abuse, security with the rule of law, and secrecy with cover-up? Why didn't the Foreign Secretary make it clear to our American friends that this country's opposition to torture meant that we would have nothing to do with intelligence gathered that way? Isn't it, Madam Deputy Speaker, our international legal duty not only to refrain from torture, but to bring those who torture to justice? That this country's long-term security is best protected when we uphold human rights and uphold the rule of law. That when it comes to upholding the values that Britain and America are supposed to share, this country will not be bullied into shabby and shady compromise.